when the CCJ gave its judgment in favor of Speednet for $792,000. Speednet wrote to the P.U.C. and said, pay up. Lo and behold, P.U.C. digs through its files and said, wait a minute, going all the way back to 2011, when we gave you provisional approval, we are now going to charge you license fees for all of those years, even though, one, they did not reassign the spectrum, two, they did not issue a license to Speednet to use the spectrum, and the law does not allow you to charge license fees unless you issue a license. Today, Madam Justice Arana totally agreed with Speednet and said that judgment is given in favor of Speednet, the fees are not due, and most importantly, she granted a permanent injunction against the P.U.C., barring the P.U.C. from demanding these fees from Speednet. The point of the matter is that, as she said, the P.U.C., get your house in order before you make these types of demands. You are suggesting that what the P.U.C. could do is reassign the frequency.
In other words, do their job.
Do their job, but now we have a problem. Can you go and collect this retroactively from someone who at the time when they were using it, you had not done your work? So my point is very simple. We specifically said to the judge we want an injunction to stop them from doing exactly that. Judge has granted that injunction. So the only way they can demand these fees from Speednet is if they appeal this and if they were to win in the Court of Appeal. I will not predict whether or not they would appeal, nor would I predict whether or not they would win if they appeal. All I will say is that the P.U.C. has a very dismal track record of going to court and losing. They refuse to do what they should do in order to make demands from people operating across the regulated utilities. They simply abuse their power every time, and the courts keep saying it to them, but they are pig-headed. They believe that they can operate above the law, and they cannot.